All rise. This Court of Appeals is now in session. The Honorable Jennifer Hensel presiding.
Good morning. Please be seated. The court has one matter set for oral argument this morning, State of Ohio versus David Gregory, Jr. The state has waived oral argument. You have 15 minutes this morning to present your argument to the court. I'm keeping the clock, and you don't need any rebuttal time. You're usually well aware of how the passage of time is going. So we've read the briefs, so ready to see where you are.
Thank you, Your Honor. Good morning, and may it please the court. As you know, I'm Jacqueline Corrigan, and I represent the appellant in this matter, Mr. David Gregory. Mr. Gregory offers 4 challenges to his conviction for the second-degree felony of illegal assembly or possession of chemicals for the manufacture of methamphetamine.
And if I could interrupt briefly, what was in the car? I know there were batteries in the car and chemical. Was the cook lab in the car?
No.
Thank you.
No. The batteries were the only items in the vehicle. I will say that there was a small package of methamphetamine. However, that was not charged to my client because that was found in the footwell next to the backseat passenger. So that was the batteries were the only things.
Thank you.
So, but that gets us right to the heart of the case, and that is that when my client was driving with an SUV with a box of batteries in the back seat of the SUV, and his offense level was elevated to a second-degree felony from a third-degree felony because when Barberton police pulled him over, they pulled him over beside Barberton High School. And of course, the statute raises the level of the offense to that second-degree felony if the offense is committed in the vicinity of a juvenile or in the vicinity of a school. Generally, it's about 1,000 feet from a school. Obviously, this was right at the edge of Barberton High School property, but my client is asserting that applying this part of the statute to him under these circumstances is vague as applied to him because for the first reason is that it's not likely, it's hardly at all likely that the Ohio legislature intended this language of in the vicinity of a juvenile or in the vicinity of a school to apply in situations where it's not the offender who chooses whether they are in the vicinity of a school or even in the vicinity of a juvenile. In this case, it was the Barberton police who chose that he was going to be in the vicinity of a school.
Well, let me stop you there because when I read the brief, I thought you're putting a lot of emphasis on where he was stopped, on the fact that it was the police who were in control over where he was stopped. But the police weren't in control of where he chose to drive. So assuming that he drove that close to, and we're not talking about a dispute between 800 feet, I mean, he was right at the school. Assuming that he chose to drive there, and assuming further that he had knowledge that he had these batteries and that the batteries were to be used to make meth, then what difference does it make where the police chose to stop him? He was there.
Well, certainly he was there. He wasn't, however, in motion, en route, until the Barberton police chose to stop him there. And
how do we know that he was not, that the school was not his intended destination?
Well, because Detective Lorella had been monitoring his movements pretty much all day on that day. And he had gone from his house, which is on Brady Street in Barberton, and I'm going to try to illustrate this backwards for you. If you were looking on the map, Brady Street would be, for instance, over here. And to get to Gland Street, where where he picked up Mr. Boichi. He had to drive west, he had to then drive north, he had to drive west again, north again, and then a little bit, I'm sorry, he had to drive east, north, and then a little bit west.
And where's Barberton High School in that configuration?
Barberton High School, let's see, about here, okay. Barberton High School is at the corner of 4th Street, which also turns into Barber Road, and then Morgan, which bisects it. And Morgan pretty much dead ends into Barber Road. Barberton High School is located on the southern corner of that intersection, and its football field and track are north of that. So when in my brief I say that Morgan bisects the campus, it truly does. What's interesting, what I was getting at with the map is that Detective Lorella had followed my client to the Glen Street location, and he testified that my client seemed to be retracing his route back to his home on Brady Street. And in fact, Mr. Boichi had testified that he was living with my client at the time. So the assumption by the police was that he was retracing his steps back to his own home. And
There's nothing in the record, I take it, that would suggest that the route that he took going directly past Barberton High School was the only way to get from point A to point B.
there's nothing in the testimony. However, on the map that was presented as one of the state's exhibits, I believe they had a map version and they had basically the satellite photo version. The only real direct route between point A and point B is through Morgan Avenue. In order to bypass that, one would have to go further south, possibly onto Worcester Road, and maybe even go into actually would have to go at a minimum into downtown Barberton, down to Lake Street. Yes, quite a bit out of the way. Quite a bit south, and then have to go north to get to Brady. So that was the only direct route, or I should say the most direct route between point A and point B. But the vagueness of this is that when the legislature was enacting all of the increased penalties for conducting drug activity in the vicinity of a school, what they were doing was their purpose was to protect children from drugs and drug activity. So as in my brief, it was intended to prevent the situation that used to happen, unfortunately, at my high school where drug deals were occurring in the junior high school parking lot. So that was the intent. And certainly there's no question that it would affect somebody who had actually stopped at a school and was offering drugs for sale, or like I said in the brief, was collecting chemicals and having a meth lab in a van within 1,000 feet of a school. But also, I think the vagueness is also illustrated by the fact that this law also raises the penalty level if the offense is committed in the vicinity of a juvenile. Now, as we know, children are not necessarily stationary like schools are. If we followed the reasoning under which my client was convicted for driving through a school area and then being stopped by a police officer next to a school, he could also be convicted or have his penalty level raised if he had, let's say, been out on a country road with this box of batteries, stopped, and a child happened to ride by on a bicycle. So it really is, this was meant by the legislature to penalize people when they are recklessly committing this offense, or they're committing this offense recklessly in the vicinity of a school or a child.
So if follow your line of thought, then if your client had the batteries, let's say the same scenario, going from point A to point B, but this time, he not only has the batteries, he's got all the other chemicals to make meth. And he's driving just past the school, and, you know, at any point there could be an explosion. Let's say he has the whole meth lab in the car. Where does that take us? And you know, he's stopped there because the police are concerned. They got a tip or whatever that he's driving near the school with his meth lab, and they're concerned that it not explode in the vicinity of the school. Where does that put us?
I think it still puts us in the same position, because unfortunately, in the scenario that you're mentioning, I hate to say this, but I would hope that the police, thinking that maybe there was an active meth lab in his vehicle that could explode, would not stop him near children or near a school. I would hope that they would be wiser than that. But again, it would be not, it's a vehicle in motion, and it's not like he was reckless in choosing to have the batteries where he did.
I'm watching the clock, and I realize that you don't have a lot of time, but I wonder if you might speak to the issue of this Brady violation.
Certainly.
And if you could just, in light of the fact that you said in your brief that the statement is not in the record before us.
No.
So I'm wondering how we can review whether it's exculpatory and if it's not in the record before us. How do we review that?
I think by looking at the rest of the interaction between Mr. Gregory's attorney and the court, you know, when he said, I have not seen this statement, I need to see this statement, the changes in Mr. Boichi's testimony and statements throughout the entire case seems to be a pattern that he does not have a straight story. His story changes all the time. Because it does, any kind of statement that he would give could potentially be used for impeachment purposes. Even if it was consistent with the statement that he had made during trial, it still would be different than the statement that he had made to police when he was initially arrested. But again, I would refer the court to the interactions that were on the record between the attorneys and the court. If there are no other questions on that issue, I would like to turn to the sufficiency and manifest weight argument, if the court will allow. And I understand I do have a limited time. But again, I'm getting right back to the in the vicinity of the school language concerning the sufficiency and manifest weight assignments of error. The legislature has not set up the language of near, in the vicinity of a juvenile or a school as a strict liability offense. It's not just, oh, it's here and therefore you're convicted of it. There is a mens rea to this element of the offense, and that element in other drug offenses, because the Ohio Supreme Court apparently has not addressed this specific statute for the illegal assembly. It's addressed this situation in other cases and said that near a school, near a juvenile, has to be committed recklessly. And recklessly in respect to circumstances where they're perversely and with heedless indifference to the circumstances, disregarding a known risk that the circumstances, in other words, being near a school, are going to occur. So the Supreme Court has dealt with that in cases of, say, dealing with LSD dealing in the vicinity of the school, and said it has to be done recklessly. And as I see that I am nearing the end of my time, if there are any further questions from the court, and if there are none, I would urge you to please reverse my client's convictions. Thank you very much.
Thank you, counsel, for your presentation this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website. Thank you. We are adjourned until